What if we told you that the way you understand justice today began in a world without cell phones, cars, or even widespread printed books? What if the laws governing your life were once written on animal skin and taught by scholars in dusty halls, shaping societies from the ground up? From 500 C to 1500 C, the very ideas of right and wrong, crime and punishment were forged in the minds of dedicated students poring over ancient manuscripts. Get ready to uncover the secrets of medieval legal texts that shaped a continent. Number 7. Corpus Juris Civilis. Picture this: the Roman Empire, a titan of law and order, fell apart in the West. Its grand legal system, built over 1,000 years, scattered into fragments. But in the East, the Byzantine Emperor Justinian, who ruled from 527 to 565 CE, had a bold vision. He wanted to gather all the Roman laws, decrees, and legal opinions into one massive, organized collection. His goal was to bring clarity and order back to the legal chaos that had started to creep in. He hired a brilliant jurist named Tribonian and a team of scholars for this monumental task. They sifted through mountains of ancient legal texts, some of them hundreds of years old, often contradictory, and sometimes written in a language that was becoming archaic even then. The result of their incredible effort was the Corpus Juris Civilis, meaning body of civil law. This was not just one book, it was a collection of several parts. The first part, the digest or pandects, was the most intellectually demanding. It was a colossal compilation of writings and opinions from Rome's most famous jurists, lawyers, and legal scholars, dating back to the Republic and the early Empire. It contained over 9,000 excerpts from 2,000 different books. Imagine trying to organize that much information without computers or even a proper index. For a medieval law student, the digest was the ultimate puzzle. Presented complex legal arguments, often discussing hypothetical cases, and provided the reasoning behind Roman legal principles. Students had to learn to think like a Roman jurist, dissecting arguments about property disputes, contracts, and family matters. The second part was the Code. This section contained the actual imperial constitutions, which were the laws issued by Roman emperors themselves. These were the actual rules governing various aspects of life, from administrative regulations to criminal statutes. It provided a direct look at the decrees that shaped the daily lives of Roman citizens for centuries. Code was often more straightforward than the digest, giving students concrete rules to memorize and apply. Then there were the institutes. This was a textbook, a beginner's guide to Roman law, designed specifically for students. It summarized the basic principles of Roman law in a more accessible format, making it easier for new learners to grasp the fundamentals before diving into the dense material of the digest and Code. It covered topics like the law of persons, things, and actions, laying out the fundamental categories of Roman legal thought. For a medieval student just starting their legal journey, the institutes provided a crucial roadmap. Finally, the Novelae Constitutions, or novels, contained the new laws issued by Justinian himself after the Code was completed. These were the latest updates to the legal system, showing how the law continued to evolve even after the grand compilation. For centuries after Justinian, the Corpus Juris Civilis largely disappeared from practical use in Western Europe, becoming a forgotten treasure. But then, in the 11th century, something incredible happened. Scholars in Bologna, Italy, began to rediscover copies of the digest and other parts of the Corpus Juris Civilis. It was like finding a lost civilization brimming with sophisticated legal ideas that were far more advanced than anything commonly in use in medieval Europe. This rediscovery sparked a legal revolution. Students flocked to Bologna and other emerging university towns like Pavia and Modena. There were often young men, aspiring to careers in the church, in royal administration, or as professional lawyers. They would sit for hours in crowded lecture halls, listening to professors known as glossators. These professors did not just read the text. They would literally write notes, called glosses, in the margins of the Corpus Juris Civilis. These glosses explained difficult passages, reconciled contradictory statements, and cross-referenced different sections of the law. A student's precious copy of the Corpus Juris Civilis would soon be covered in these handwritten notes, turning it into a dense web of information. The study of the Corpus Juris Civilis was rigorous. Students memorized principles, debated hypothetical cases, and learned to apply logical reasoning to complex legal problems. They learned Latin, the language of the texts, and immersed themselves in a world of Roman legal concepts like dominium, ownership, obligatio, obligation, and persona, legal personhood. They learned how to draft contracts, analyze property rights, and understand the intricacies of civil procedure. A deep understanding of Roman law, gained through this text, became a mark of high education and opened doors to powerful positions. Many future popes, emperors, and high-ranking officials began their careers as students of the Corpus Juris Civilis. Its influence was not just academic. It shaped the legal systems that emerged across continental Europe, laying the groundwork for many of the civil law traditions that exist today. It was the bedrock upon which the entire legal education of the Middle Ages was built, a testament to the enduring power of ancient wisdom. Number 6. Decretum Gratiani. Imagine a world where disputes were often settled by religious courts, where laws about marriage, inheritance, and even business contracts were intertwined with the rules of the church. That was the reality for many in the Middle Ages. The church, as a powerful institution, developed its own body of law, known as canon law. But like Roman law before Justinian, canon law was a tangled mess. It consisted of scattered papal decrees, decisions from church councils, biblical passages, writings from early church fathers, and local customs. It was hard to find a clear rule on anything, and contradictions were everywhere. Enter Gratian, a monk who taught at the monastery of Saints Felix and Neighbor in Bologna, the same city where Roman law was experiencing its great revival. Around 1140 CE, Gratian took on an incredibly ambitious project. He aimed to collect, organize, and most importantly, reconcile the vast, often conflicting sources of canon law. He published his work, which he called Concordia Discordantium Canonum, or Concordance of Discordant Canons. Students and scholars, however, simply referred to it as the Decretum Gratiani, or Gratian's decree. This was not just a collection of laws. Gratian used a method of intellectual inquiry called disputatio. He would present a legal question, then cite various authorities that seemed to contradict each other, and then provide a resolution or explanation, often by distinguishing between different types of laws or the specific circumstances in which they applied. He was essentially trying to bring order out of chaos, making canon law a more coherent and logical system. For a medieval student, the Decretum Gratiani was a massive textbook. It was divided into 3 main parts. The first part dealt with the sources of canon law and the fundamental principles of the Church. It explored topics like the divine origin of law, the authority of the Pope and bishops, and the nature of ecclesiastical courts. The second part was a collection of cases, each presented with a legal question, followed by arguments for and against a particular answer drawn from various canon law sources. Gratian then offered his own reasoned solution. These cases covered a huge range of issues from marriage law, which was a significant part of the Church's jurisdiction, to property disputes involving monastic orders, and even the conduct of clergy members. The third part focused on liturgical matters and sacraments, such as baptism and Eucharist, outlining the Church's rules and practices related to these sacred rites. Studying the Decretum meant wrestling with complex moral and legal dilemmas. Students would learn about the intricacies of canon law procedure, the rules for valid marriages, the grounds for annulment, and the proper administration of church property. They would debate the powers of the Pope versus the powers of secular rulers, a constant source of tension in medieval society. Gratian's work taught them how to navigate the complex relationship between spiritual authority and temporal power. Professors, often called Decretists because they studied the Decretum, would lecture on its contents, adding their own glosses and commentaries, just as the Roman law scholars did. Students aspiring to careers in the church hierarchy, as bishops, abbots, or papal legates, found mastery of the Decretum essential. It was also crucial for those who aimed to serve in the legal departments of royal or imperial courts, as conflicts between church law and secular law were common, requiring individuals who understood both systems. The Decretum Gratiani was not an official law code issued by the Pope. It was a private collection, but its brilliance and comprehensive nature meant it quickly became the standard textbook for canon law throughout Europe, provided the structure and framework for all subsequent canon law development. Its influence extended far beyond the Church, shaping ideas about marriage, family, and contracts that eventually found their way into secular legal systems. It highlighted the Church's role not just as a spiritual guide, but also as a powerful legal and judicial authority, overseeing a vast network of courts and legal professionals. Questions Gratian posed and the methods he used to answer them became the very foundation for canon law scholarship, making it a dynamic and intellectually stimulating field of study for centuries to come. Number 5. Liber Extra. Even after Gratian's monumental Decretum, the legal landscape of the Church continued to evolve rapidly. Popes issued new decrees, known as decretals, to address new challenges, resolve disputes, and clarify points of law. These new decretals were essential for the functioning of the Church, but they began to accumulate in a disorganized fashion, creating new layers of complexity and contradictions, much like the situation Gratian had tried to solve a century earlier. Students and lawyers had to sift through numerous small collections of these new laws, often compiled by private individuals, making it difficult to find the definitive rule. This growing problem reached a critical point in the early 13th century. Pope Gregory IX, who reigned from 1227 to 1241 CE, recognized the urgent need for a new authoritative compilation of these papal decretals. He commissioned Raymond of Pennafort, a renowned Dominican friar and canon lawyer, to undertake this task. Raymond was a master of organization and a highly respected jurist. He was tasked with collecting all the significant papal decretals issued since Gratian's time, along with some earlier ones not included in the Decretum, and arranging them into a clear, systematic code. The result, published in 1234 CE, was officially titled Decretales Gregori Noni, but everyone called it Liber Extra, which means the book outside of Gratian's Decretum. Unlike Gratian's work, Liber Extra was an official papal promulgation. This meant it was the definitive, binding law for the entire Latin Church. It immediately superseded all earlier unofficial collections of decretals. If a lawyer or student wanted to know the official stance of the Church on a matter, they turned to Liber Extra. The Liber Extra was organized into 5 books, a structure that became a standard for future canon law compilations. Each book dealt with a specific area of law. Book 1 focused on the roles and powers of judges, ecclesiastical offices, and the appointment of clergy, clarified the hierarchy within the Church and the authority of various church officials. Book 2 dealt with judicial procedure, including how cases were brought before ecclesiastical courts, the rules of evidence, and the process of appeals. This was crucial for students learning how to practice law within the Church's system. Book 3 covered the conduct of clergy, the administration of sacraments, and the nature of ecclesiastical property. It addressed issues like simony, the proper dress for clerics, and the management of church lands and revenues. Book 4 was entirely dedicated to marriage law. This was a hugely important area, as the Church had significant jurisdiction over marriage and family matters throughout medieval Europe. It detailed the requirements for valid marriages, grounds for annulment, and the rights and duties of spouses. Book 5 contained a diverse range of topics, including criminal law, heresy, forgery, and the rules of the Church's internal governance. It covered various offenses against the Church and society, and the penalties associated with them. For medieval law students, Liber Extra was a fundamental part of their canon law studies, building directly upon the foundations laid by Gratian's Decretum. Students would spend countless hours memorizing its rules, understanding the nuances of its legal language, and learning how to apply its principles to real-world situations. They studied how the Pope's legislative power functioned, and how new laws were created and implemented. They learned about the processes of the church courts, from initiating a case to delivering a verdict, which was vital for anyone hoping to become a canon lawyer or a church administrator. The lectures on Liber Extra were intensive. Professors, now called decretalists, because they studied the decretals, would guide students through its complex provisions, providing commentaries and explanations. Students would engage in disputations, debating the interpretation of specific decretals and their application to hypothetical cases. Mastering this text was essential for any aspiring church, official, clergyman, or legal professional who wished to practice in the ecclesiastical courts that dotted the landscape of medieval Europe. The Liber Extra represented the maturing of canon law as a distinct and highly sophisticated legal system, capable of handling a vast array of legal problems and maintaining order within the vast network of the Church. It was a living body of law, constantly applied and interpreted, shaping not just the lives of clergy but also the daily existence of ordinary people through its influence on marriage, family life, and property rights. Number 4. Glossa ordinaria. Imagine trying to read a complicated legal document from 1,000 years ago, written in a language you only partially understand, full of technical terms and references to other laws you have never seen. That was the challenge for medieval law students studying the Corpus Juris Civilis. The original texts, especially the digest, were incredibly dense, sometimes contradictory, and often needed clarification. Simply reading them was not enough. Students needed guides, interpreters, and detailed explanations to unlock their meaning. This is where the glossators came in. These were legal scholars, primarily from the University of Bologna, who dedicated their lives to understanding and teaching Roman law. Their primary method of instruction was to write glosses, notes, or explanations directly onto the margins of the Corpus Juris Civilis manuscripts. These glosses could be short explanations of a single word, longer discussions of a difficult passage, or cross-references to other parts of the text where a similar legal principle was discussed. Over time, these individual glosses accumulated. Many scholars would add their own comments, leading to a rich but sometimes confusing tapestry of annotations around the main text. By the early 13th century, the sheer volume of glosses had become overwhelming. Different scholars had different interpretations, and it was hard for students to know which gloss was authoritative or most widely accepted. It was like having a textbook where every paragraph had 20 different footnotes from various authors, each one adding to the confusion. This is where Accursius, a prominent legal scholar at the University of Bologna, stepped in. Accursius, who lived from around 1182 to 1263 CE, undertook the monumental task of compiling and synthesizing all the existing glosses on the Corpus Juris Civilis. He sifted through hundreds of thousands of individual glosses written by earlier masters, selecting the most important, clarifying conflicting interpretations, and adding his own insights. The result was the glossa ordinaria, or ordinary gloss. This was not a new legal text in itself, but rather the definitive standardized collection of glosses that accompanied the Corpus Juris Civilis. It became the authoritative commentary, often printed or copied alongside the main text. If a student bought or borrowed a copy of the Corpus Juris Civilis, it almost certainly came with Accursius's glossa ordinaria wrapped around it. For a medieval law student, the glossa ordinaria was an indispensable study tool. It was their main guide through the labyrinthine world of Roman law. When they read a passage in the digest that seemed obscure, they would immediately look to the surrounding glosses. These glosses explained the meaning of ancient Latin words, provided definitions of complex legal terms, offered summaries of lengthy discussions, and pointed out where different parts of the Corpus Juris Civilis related to one another. The glossa ordinaria also contained hypothetical examples and case studies, showing students how abstract legal principles could be applied to concrete situations. Lectures in Bologna and other law schools often centered around the glossa ordinaria. Professor might read a passage from the digest, then turn to Accursius's commentary, explaining it further or debating its interpretations. Students would be expected to not only understand the original Roman law, but also the accepted interpretations provided by Accursius. Learning to navigate the glossa ordinaria was a skill in itself. It taught students how to read, analyze, and synthesize complex legal arguments from multiple sources. It was a rigorous training in legal reasoning and scholarship. The glossa ordinaria became so influential that it was said, "What the gloss does not recognize, the court does not recognize." This phrase highlights its immense authority. It wasn't just a study aid. It was practically part of the law itself for legal practitioners and judges. It provided a common language and a shared understanding of Roman law across different regions and legal systems. Its presence ensured a consistent interpretation of the Corpus Juris Civilis, allowing lawyers and judges from different parts of Europe to communicate and apply the same legal principles. It became the bedrock for the later development of civil law in Europe, influencing legal thought and practice for centuries. Accursius's work made the incredibly complex Roman law accessible to generations of students, shaping the minds that would go on to build the legal foundations of modern Europe. Number 3. Libri Foedorum. Imagine a society where land was not simply owned, but held in a complex web of duties and allegiances. This was the reality of feudalism in medieval Europe, a system built on relationships between lords and vassals, where military service and loyalty were exchanged for grants of land. While Roman law and canon law dealt with broad principles and ecclesiastical matters, feudal law addressed the everyday practicalities of property, power, and obligations that shaped much of medieval life. However, unlike the ancient Roman laws or papal decrees, feudal law was largely based on custom, local practices and agreements, often passed down orally. This meant there was no single unified code of feudal law, making it challenging to understand and apply consistently across different regions. Yet as legal education flourished, particularly with the revival of Roman law, there was a growing need to systematize and study these feudal customs. Students aspiring to work for princes, kings, or powerful landowners needed to understand the intricate rules governing land tenure, inheritance, and the rights and duties that came with various feudal holdings. This demand led to the compilation of the Libri Foedorum, or Books of Feudal Law. This was not a single official legislative act, but rather a collection of feudal customs and decrees, primarily originating from Lombardy in northern Italy, an area where feudal relationships were particularly well developed and documented. The Libri Foedorum was assembled gradually, likely starting in the 11th century, and was subject to various revisions and additions over time. It eventually came to be seen as the most authoritative collection of feudal law. For medieval law students, the Libri Feudalorum became an essential part of their curriculum, often studied alongside the Corpus Juris Civilis itself. In many law schools, the Libri Feudalorum was treated almost as an appendix to Justinian's code, recognizing that while Roman law provided the theoretical framework, feudal law governed much of the practical reality of landholding and political power. The Liber Feudalorum detailed the various types of feudal tenures, from military feuds to service feuds, and outlined the specific obligations and rights associated with each. It clarified issues like investiture, the formal act by which a lord granted a fief, land, or rights to a vassal; homage and fealty, the oaths of loyalty and service sworn by a vassal to his lord; inheritance of fiefs, rules about how feudal holdings passed down through generations, including rights of succession for sons and, in some cases, daughters; forfeiture, the conditions under which a vassal could lose his fief, such as breach of loyalty or failure to perform services; feudal incidents, specific payments or services due from a vassal to his lord, such as relief, payment upon inheritance, or wardship, the lord's right to manage the fief of a minor heir. Studying the Libri Feudalorum provided students with a practical understanding of how medieval society was structured and how power operated at the local level. They learned about the legal basis of land ownership, the intricate relationships between different social classes, and the disputes that commonly arose in a feudal system. Professors, often glossators of Roman law, would also teach the Libri Feudalorum, using their analytical skills to interpret and systematize the feudal customs. Students would analyze hypothetical feudal disputes, such as a vassal claiming his lord had violated an agreement, or a lord seeking to reclaim a fief due to a vassal's disloyalty. Mastery of the Libri Feudalorum was particularly valuable for students aiming for careers in secular administration, working for kings, dukes, or powerful counts. These roles often involved managing vast estates, resolving land disputes, and advising rulers on their feudal rights and obligations. It allowed them to understand the economic and political realities of medieval Europe, where land was the ultimate source of wealth and power, and feudal relationships were the glue that held the social fabric together. The Libri Feudalorum demonstrates that medieval legal education was not confined to ancient Roman texts, but also embraced the living, evolving customary law that shaped the daily lives of the people and the political landscape of the time. It offered a practical counterbalance to the theoretical sophistication of Roman law, ensuring that students were prepared for the diverse legal challenges of their world. Number 2. Bracton's De Legibus et Consuetudinibus Anglii. While much of continental Europe was immersed in the revived Roman law and developing canon law, England was forging its own distinct legal path: the common law. This system was not based on ancient Roman codes or papal decrees, but on judicial decisions, customs, and precedents established by royal courts. For a long time, this common law was largely unwritten, residing in the memories of judges and lawyers and in the records of court cases. This made it challenging to study systematically. There was no single authoritative textbook that laid out the principles of English common law in a comprehensive way. This changed dramatically with Henry de Bracton, a remarkable English cleric and judge who lived from around 1210 to 1268 CE. Bracton, who served as a royal justice and was deeply learned in both common law and Roman law, undertook the monumental task of writing a treatise on English common law. His work, De Legibus et Consuetudinibus Anglii, on the laws and customs of England, was not just a collection of rules. It was a systematic and theoretical exposition of English law, drawing on vast numbers of actual court cases and legal records. Bracton's treatise was groundbreaking for several reasons. It attempted to organize the sprawling mass of English common law into a coherent structure akin to the systematic approach found in Roman law texts. It used thousands of legal decisions or rolls from the royal courts as his primary sources, meticulously analyzing them to extract underlying legal principles. This was an unprecedented approach for English law, which until then had relied heavily on oral tradition and sporadic compilations of writs. For students and practitioners of English common law, Bracton's De Legibus became an invaluable resource. It was a massive work, often comprising multiple volumes in manuscript form. It covered a vast array of topics, including actions and writs, the formal legal procedures through which cases were initiated in royal courts. Bracton detailed the specific writs or commands from the king that were necessary to bring different types of legal claims. Understanding these writs was fundamental to practicing common law. Property, law, rights related to land ownership, inheritance, and various forms of land tenure. This was particularly important in feudal England, where land was the cornerstone of wealth and power. Criminal law, definitions of various crimes, and the procedures for prosecution and punishment. Civil procedure, the rules governing how cases were heard, evidence was presented, and judgments were rendered. Royal prerogative, the powers and authority of the king, and the limits on those powers, a concept that would become increasingly important in later English constitutional history. Bracton's work was unique because he integrated elements of Roman legal thinking and structure into his analysis of English common law. He did not simply copy Roman law, but used its logical framework to impose order on the English legal system. He discussed concepts like jurisdiction and possession with a sophistication that was new to English legal writing. Students studying law in England, particularly at institutions like the Inns of Court in London that began to emerge as centers of legal education, would pore over copies of Bracton. It was a foundational text for anyone aspiring to become a barrister, a judge, or a royal official. They learned not just what the law was, but also the historical development of legal principles, tracing how previous court decisions shaped current law. Lectures and informal discussions would revolve around Bracton's interpretations of specific cases and his general principles. The sheer volume of material meant students had to develop strong analytical and memorization skills. The influence of Bracton's De Legibus extended for centuries. It became the authoritative statement of English common law for generations, frequently cited by judges and lawyers. It helped to solidify the idea of common law as a coherent and sophisticated system, distinct from the civil law of the continent. Provided a common vocabulary and a shared understanding of legal principles, making it possible for judges across England to apply the law consistently. Bracton's pioneering effort in systematizing English common law laid the groundwork for its future development, ensuring that it could be taught, studied, and applied in a consistent and principled manner, shaping the legal traditions that would eventually spread far beyond England's shores. Number 1. Sachsenspiegel. While Roman law and canon law provided a universal framework for much of Europe, and English common law developed its unique path, many regions on the continent still relied heavily on their own ancient customs, local traditions, and oral laws. These customs governed the daily lives of ordinary people, dealing with everything from property rights and inheritance to disputes between neighbors and criminal offenses. But because these laws were often unwritten and varied from one village to the next, they could be unclear, difficult to enforce, and challenging to pass down consistently. In the German-speaking lands, a fascinating development occurred in the early 13th century. Ike of Reckau, a Saxon knight and legal scholar, undertook the task of compiling and writing down the customary law of Saxony. His work, the Sachsenspiegel, literally Saxon Mirror, completed around 1230 CE, became the most important collection of German customary law of the Middle Ages. It was not a law code issued by a king or an emperor, but rather a private attempt to record and organize the existing customs, which quickly gained immense authority due to its clarity and comprehensiveness. The Saxon Spiegel was originally written in Latin, but Eck himself soon translated it into Low German, the vernacular language of the region. This was a crucial step, as it made the law accessible to a much wider audience beyond just Latin-speaking scholars and clerics. It was designed for use by judges, lawyers, and anyone involved in the legal administration of the land. For medieval students, particularly those in the German-speaking regions, the Saxon Spiegel offered a practical guide to the laws that directly affected the lives of the people they would serve. It covered two main areas: land law, Landrecht. This section dealt with the intricate rules governing land ownership, inheritance, and the feudal obligations related to land. It detailed the various types of property, how it could be bought and sold, the rights of tenants, and the complex rules of succession for different social classes, from nobles to peasants. Feudal law, Landrecht. This part focused specifically on the relationships between lords and vassals, including the creation and inheritance of fiefs, military service obligations, and the rights and duties of both parties in a feudal contract. This was similar to the Libri Feudorum in content, but specific to the Saxon legal tradition. The Saxon Spiegel also contained provisions related to criminal law, marriage, and family matters, illustrating the breadth of its coverage of customary law. It described the processes of local courts, the use of oaths and forms of trial, including in some cases the use of trial by combat. It even included intricate details about the rights of different social groups from the emperor down to the peasants, reflecting the highly stratified nature of medieval society. Studying the Saxon Spiegel meant engaging with the living law of the land. Students would learn about the unique legal concepts and terminology specific to Saxon customary law. They would analyze hypothetical disputes over land boundaries, inheritance claims, or criminal offenses, learning how to apply the principles laid out by Eck of Recco. Text often included illustrations in its more elaborate manuscript versions, which helped to visually represent the legal concepts, such as the different forms of land tenure or the process of a legal dispute. Professors would teach the Saxon Spiegel by explaining its provisions, comparing them to Roman law or canon law where relevant, and discussing their practical application. Students aspiring to become local judges, scribes, or administrators for regional lords found mastery of this text indispensable, prepared them to manage the legal affairs of towns, villages, and noble estates, where the local customary law was often the primary source of justice. The Saxon Spiegel became incredibly influential. It was copied, widely translated into other German dialects, and even influenced the legal systems of other Germanic territories beyond Saxony. It served as a template for other mirrors of customary law, inspiring similar compilations in other regions. Its impact on German legal development was profound, providing a stable written foundation for a legal system that had previously been based on oral tradition. It solidified the authority of customary law, allowing it to coexist and interact with the more universal Roman and canon law, and shaping the unique legal landscape of medieval Germany. It showed that local legal traditions, when carefully documented and systematized, could become powerful and enduring forces in shaping society.